Buonasera a tutti e benvenuti a questo webinar di presentazione dei corsi in lingua inglese offerti dal Dipartimento di Giurisprudenza. Si inserisce questa dei corsi in lingua inglese tra le attività di internazionalizzazione promosse dal nostro Dipartimento. Quest'anno peraltro abbiamo avuto oltre 100 studenti Erasmus in ingresso, molti dei quali seguiranno questi corsi in inglese insieme ai studenti fredericiani, favorendo quindi anche una reciproca comprensione fra culture diverse, valore in questo particolare momento della storia europea certamente di innegabile importanza. Per il caso di ricordare che l'internazionalizzazione degli studi, in particolare giuridici, caratterizza il nostro Ateneo fin dalla fondazione nel 1224 o certamente dal 1239, anno in cui Federico II ammise a frequentare lo studium napoletano anche gli ultramontani, ossia gli studenti d'Oltralpe, di paesi diciamo al di fuori della penisola. Ho il piacere di portare i saluti del direttore di dipartimento, il professor Sandro Staiano, che purtroppo oggi non potrà essere fra noi, e cedo con piacere la parola alla professoressa Lucia Picardi, che è la coordinatrice della laurea magistrale in giurisprudenza. Prego.
Grazie infinite. Io desidero anzitutto porgere il mio saluto ai colleghi che si impegnano in questo importante sforzo, agli studenti che sono collegati e a tutti coloro che ci ascolteranno. Salutiamo anche il nostro direttore che purtroppo non ha potuto fisicamente o virtualmente, diciamo, essere con noi. È con grande gioia e soddisfazione che partecipo per il secondo anno di seguito a questo webinar di presentazione dei corsi erogati in lingua inglese, che si colloca in una linea di continuità anche temporale con l'iniziativa che si svolgerà domani di presentazione dell'offerta formativa del Dipartimento di Giurisprudenza e quindi anche del corso di laurea magistrale in giurisprudenza. Riallacciandomi a quanto appena detto il collega ed amico Arena, mi limito a sottolineare l'importanza dei corsi in lingua inglese nello sforzo di internazionalizzazione del nostro Dipartimento che pur, come lui ci ha detto, venendo da lontano, abbiamo cercato poi di come dire, rafforzare negli ultimi anni e questo grazie anche all'instancabile lavoro direi non solo organizzativo ma anche poi di tessitura di rapporti internazionali che è condotto da alcuni colleghi. I corsi in lingua inglese, è appena il caso di dirlo appunto, hanno una importanza centrale sia nella nuova offerta formativa del Dipartimento e sia più in generale nella formazione del giurista moderno. E si consentono innanzitutto, agevolano innanzitutto la frequenza da parte degli studenti stranieri, che abbiamo visto essere in numero cospicuo, ma poi danno anche la possibilità ai nostri studenti di destreggiarsi e di acquisire familiarità e pratica con una lingua diversa dalla propria. Del resto la conoscenza, diciamo, di una lingua straniera, in particolare l'inglese, è oggi un momento necessario, imprescindibile della formazione del giurista moderno, funzionale anche a consentirgli di orientarsi in una realtà in continuo movimento, di acquisire metodologie comparatistiche che gli consentano di confrontarsi con altri ordinamenti diversi dal proprio. E seppure ve ne fosse bisogno, e penso che invece non ve ne sia, ecco, il momento attuale, così drammatico che stiamo vivendo, dimostra come il giurista debba anche conoscere le istituzioni, il diritto dell'Unione Europea e debba anche essere in grado di muoversi con riferimento ad istituzioni di dimensione globale. E allora, data appunto l'importanza della dimensione internazionale e comparatistica, vorrei sottolineare come la erogazione dei corsi in lingua inglese abbracci diversi settori disciplinari, non soltanto quelli più spiccatamente internazionalistici ed eurounitari, ma anche i settori storici, oppure nonché romanistici. E questo dimostra come la formazione culturale, la base culturale dovuta allo studio delle materie filosofiche, storiche, romanistiche, rappresenta come dire, uno zoccolo duro del quale non si può fare a meno nella costruzione del profilo del giurista moderno. Ma la erogazione dei corsi in lingua inglese credo sia poi non possa andare disgiunta anche da come dire, una sorta di evoluzione delle metodologie di insegnamento. I corsi in questione sono corsi, come dire, progrediti, che quindi si collocano in anni successivi al primo e quindi in una fase piuttosto già un po' più avanzata della formazione dello studente, e questo probabilmente consente di andare oltre la tradizionale lezione cattedratica e di affinare anche le capacità di ricerca ed argomentative dello studente. Quindi una sorta di salto di qualità anche nei metodi di insegnamento, in modo tale da fare della lezione non tanto, diciamo, un'esercitazione intellettuale o una dimostrazione di capacità oratoria da parte del docente, ma proprio un momento, come dire, di attività positiva della mente dello studente. Ed ecco allora che con questo auspicio e anche con l'augurio che il numero dei corsi possa aumentare nel tempo, e anzi devo fare anche un piccolo mea culpa, perché forse noi professori di diritto commerciale non siamo presenti come invece dovremmo esserlo, con un corso anche rientrante nel nostro settore scientifico disciplinare. Io auguro ai docenti e agli studenti un buon lavoro, un semestre ricco di soddisfazioni e di risultati estremamente positivi. Grazie.
Molte grazie professoressa Picardi. In effetti ci sono alcuni rilievi estremamente puntuali, così come condivido l'auspicio dell'aumento dei corsi erogati in lingua inglese, magari anche diciamo, del ramo del diritto commerciale, di sicuro interesse per gli studenti federiciani e per gli studenti Erasmus. Alcuni di questi corsi in lingua inglese si inseriscono nel piano di studi della laurea triennale in scienze dei servizi giuridici. Quindi ora passerei la parola al coordinatore Lorenzo Zoppoli, il quale però non poteva essere tra di noi oggi, e quindi passerei la parola al professor Delfino per un indirizzo di saluto. Prego.
Sì, grazie Amedeo. Un rapido saluto a nome di Lorenzo Zoppoli, appunto come diceva Amedeo Arena non può essere presente qui con noi, premettendo che io non sono in L14 ma in LMG01, quindi riferisco diciamo l'esperienza dei colleghi che sono sulla laurea in scienze dei servizi giuridici. Come sapete, la laurea in scienze e servizi giuridici è al secondo anno di attivazione, quindi c'è il primo e il secondo anno, non ancora il terzo. Però un paio, 2 o 3 insegnamenti a scelta sono mutuati, in lingua inglese sono mutuati anche da LMG01, e quindi potrebbe accadere che qualche studente sia interessato, ci siano anche studenti di scienze dei servizi giuridici a seguire i 2 o 3 insegnamenti erogati in lingua inglese. Dubito che ci siano degli Erasmus che abbiano opzionato nell'ambito di scienze dei servizi giuridici, e quindi però diciamo ha senso il coinvolgimento di questo corso di studi, perché non è detto che non ce ne saranno in futuro, perché ci potrebbero essere Erasmus in futuro, nel momento in cui si completerà il ciclo, ci sarà il terzo anno, negli anni successivi, ci potrebbero essere studenti interessati, anche Erasmus interessati a scienze dei servizi giuridici. È capitato nel passato, quando noi avevamo soltanto LMG01, c'erano nei miei corsi di diritto del lavoro dell'Unione Europea degli studenti diciamo, iscritti in altro ateneo, in ateneo di altro paese europeo, che non erano iscritti alla quinquennale o alla laurea principale in giurisprudenza, ma in lauree triennali, che hanno seguito, penso nell'anno accademico 2015-2016, se ricordo bene, il mio corso di diritto del lavoro dell'Unione Europea in lingua inglese, e quindi potrebbe accadere che in futuro ci siano studenti della triennale, Erasmus sulla triennale, quindi interessati a seguire la triennale e quindi anche insegnamenti in lingua inglese. Valgono, diciamo, condivido appieno le cose che ha, diciamo, i profili che ha toccato la professoressa Picardi, che sono i profili, diciamo, che riguardano anche la laurea in scienze dei servizi giuridici. Naturalmente un auspicio di carattere generale, visto che parlo a nome del coordinatore di uno dei due corsi di studi, e che è quello secondo il quale, diciamo, in base al quale i corsi in lingua servano anche agli studenti italiani. Cioè, diciamo, la nostra offerta in lingua inglese è erogata, a mio avviso, a favore degli studenti Erasmus, cioè degli studenti che non sono madrelingua italiana, ma anche a favore di alcuni studenti italiani, cioè di quegli studenti che hanno un profilo internazionale, una predisposizione per l'internazionalizzazione più elevata di altri, che magari sono incuriositi, diciamo, sono disposti a seguire un corso in una lingua diversa dalla propria, che però spesso è anche una lingua diversa da quella degli studenti Erasmus, perché raramente gli studenti Erasmus sono madrelingua inglese. E quindi, diciamo, è un terreno neutro, linguistico neutrale, sul quale, diciamo, si fa l'europeizzazione e anche l'internazionalizzazione, a mio avviso, e potrebbe essere, diciamo, un terreno interessante, almeno questa è la mia esperienza del passato, perché è il primo anno che ho di nuovo l'insegnamento in lingua inglese dopo 3 o 4 anni accademici. E quindi il mio auspicio è questo, indipendentemente dalla laurea quinquennale, laurea magistrale in giurisprudenza o dalla laurea, diciamo, triennale in scienze dei servizi giuridici, il mio auspicio è che questo possa essere un terreno fertile per l'europeizzazione e per l'internazionalizzazione delle nostre università a partire appunto dal nostro dipartimento. Grazie, grazie.
Grazie Massimiliano, e in effetti penso che tu abbia inconsapevolmente citato Michel Godé, che nel 18 ottobre del 1963 affermava che soltanto attraverso la cooperazione tra i giuristi dei diversi paesi europei può realizzarsi l'apprendimento del diritto comunitario e quello spirito europeo che è alla base della comprensione comune e della tolleranza. E ancora una volta credo che si tratti di valori particolarmente importanti in questa ora buia della storia europea. Abbiamo sentito più volte parlare di Erasmus che ricordiamo ha anche una madre italiana, Sofia Corradi, e quindi con grande piacere passo la parola alla professoressa Valeria Costantino, che è delegata del rettore per il programma Erasmus. Prego Valeria.
Grazie Amedeo, prima di tutto grazie per avermi invitato a questa riunione. Mi fa molto piacere come sempre intervenire ai meeting organizzati presso il vostro dipartimento, che è estremamente attivo nel campo della internazionalizzazione, e porto i saluti del magnifico rettore Matteo Lorito e il suo applauso per l'attività intensa in tema internazionalizzazione che viene svolto nel vostro dipartimento. Sono molto contenta di vedere quanti corsi vengono erogati in lingua inglese in un dipartimento che ovviamente, pur essendo molto grande e molto attivo, potrebbe non essere quello con la maggiore vocazione ai corsi in lingua inglese. Non è una laurea di tipo STEM, di tipo scientifico, dove questa vocazione è abbastanza naturale. Quindi penso che l'impegno, lo sforzo che viene profuso per creare questi corsi in lingua inglese, che sono profondamente d'accordo con il collega che mi ha preceduto, non servono soltanto ad accogliere gli studenti internazionali, ma soprattutto a creare delle aule virtuali internazionali, delle aule in cui i nostri studenti possano mettersi in gioco con una lingua che è quella internazionale utilizzata in tantissimi ambienti, ma soprattutto mettere in gioco la possibilità di studiare non usando la madrelingua. Questo è un esercizio, penso, culturale di particolare importanza. Quindi non voglio togliere spazio alle presentazioni, invito quanto più studenti possibili italiani dei nostri corsi di studio a partecipare a questi corsi e il supporto da parte dell'ufficio Relazioni Internazionali e di tutti i delegati all'internazionalizzazione è sempre a favore di tutte queste attività. Quindi ringrazio Amedeo in particolar modo perché è un ottimo organizzatore e ringrazio tutti i colleghi che, ripeto, fanno uno sforzo particolare per rendere le aule di Federico II quanto più internazionali possibili. E buon lavoro a tutti.
Grazie ancora Valeria per il saluto del rettore, per le parole di apprezzamento nei confronti dell'attività di internazionalizzazione del nostro dipartimento. Tra l'altro, oltre l'Erasmus c'è quest'anno un'altra opportunità, che è quella del Network Aurora, perché alcuni di questi corsi in inglese saranno offerti anche agli studenti degli atenei che costituiscono questa alleanza, quindi per esempio l'Università di Amsterdam, l'Università dell'Islanda, dell'East Anglia, di Duisburg, di Aberdeen e ancora di Innsbruck, e quindi, quindi questo consentirà, anche al di là dell'Erasmus o in aggiunta all'Erasmus, di creare queste classi, alcune delle quali, appunto, come dicevi, virtuali, dove si potrà appunto realizzare questa pluralità di culture nell'apprendimento del diritto, e quindi continuo confronto e reciproco arricchimento. Passo ora con piacere la parola alla professoressa Valeria Marzocco, Presidente della Commissione Orientamento. Prego Valeria.
Grazie Amedeo, chiudo io questa sessione di saluti, che però contiene anche un bel po' di elementi e di stimoli, perché innanzitutto nella individuazione della platea alla quale ci stiamo riferendo penso che siano state già come dire, messe sul tavolo una serie di questioni che a mio avviso sono anche questioni rispetto alle quali il Dipartimento si è molto impegnato negli ultimi anni sotto il profilo anche del rinnovamento dell'offerta formativa. Noi stiamo parlando di corsi in inglese, io ringrazio molto Amedeo per lo sforzo costante che certamente in qualità di delegato per l'internazionalizzazione di questo Dipartimento, ma anche animato da una passione autentica, profonde nella diffusione e anche nella, diciamo, nella implementazione di questi corsi. Stiamo parlando di corsi in lingua inglese, e però stiamo parlando di corsi in una lingua inglese che è la lingua giuridica, e questo è un elemento estremamente interessante nella misura in cui è vero che noi come facoltà, come dipartimento che chiaramente ha come oggetto un tema che è tipicamente appartenente alle scienze umane, probabilmente non abbiamo una vocazione dal punto di vista anche del modo in cui tra di noi, no, circola il sapere nel linguaggio inglese, ma è anche vero che il giurista contemporaneo, la giurista contemporanea non può fare a meno di confrontarsi con un inglese giuridico che non è esattamente l'inglese che naturalmente può essere impartito all'interno di luoghi altri che non siano il Dipartimento di Giurisprudenza. Quindi innanzitutto certamente ancora il mio ringraziamento ad Amedeo, che in questo senso porta avanti un'iniziativa che certamente si rivolge agli studenti Erasmus, ma si rivolge, sono molto d'accordo, ai nostri studenti, ma anche ai colleghi che naturalmente mettono in campo la scienza del diritto con riguardo a quel modo di insegnare appunto la scienza del diritto che non si confronta solo con una lingua che è una lingua altra, ma che si confronta con gli istituti, con le categorie, con il modo di esprimere i concetti che naturalmente una lingua come la lingua inglese chiama in causa. E questa non è una sfida, è una realtà. Abbiamo fatto più o meno velatamente, forse con un po' di cautela, forse anche con un po' di pudore, riferimento ai tempi difficili che stiamo vivendo. Sono tempi che paiono non finire mai, ma che ci portano davanti a delle responsabilità che soprattutto chiamano in causa la responsabilità del giurista, nell'interpretazione della realtà che ci circonda, ma anche nella capacità di, permettetemi, gestire e quindi interpretare le categorie, perché attraverso le categorie il giurista legge la realtà. Qui è certamente, parlo forse un po' meno da referente per l'orientamento, un po' più da filosofa del diritto, ma consentitemi questo piccolo riferimento alla mia materia, che mi auguro presto possa essere tra quelle che offrono insegnamenti in lingua inglese, stante chiaramente quella che è la vocazione culturale, storica che la attraversa. Grazie a tutti e la parola con grande piacere e ascolterò finché posso anche i colleghi che ringrazio.
Grazie ancora Valeria, anche io mi associo a questo auspicio, anche perché si tratta ancora una volta di considerazioni estremamente puntuali. Rivolgersi a una platea diversa impone a volte un ripensamento delle categorie, delle metodologie, e quindi un arricchimento in effetti tanto per i docenti quanto per i discenti, Fredericiani, Erasmus, Aurora, e quindi insomma qualsiasi titolo fruitori di questa offerta didattica. So it's now time to switch to English and to hand over to the colleagues who are going to offer the 11 modules taught in English in the context of the current academic year. And just before just before I hand over to Professor Iovane, I'd like to mention that this kind of offer, so the idea of offering courses to students from different places, is part of the tradition of the University of Naples, Federico II. Indeed, the founder of our university, Frederick II, spoke 6 languages himself, and in 1239 he expressly invited to attend the University of Naples students from beyond the mountains. So essentially he was referring to students that will come from countries other than Italy. So without any further ado, let me hand over to Professor Massimo Iovane, who is going to teach international protection of human rights.
Good afternoon. Thank you very much, Amedeo. International protection of human rights is a popular subject among Erasmus students, I must say. All along also it's an attraction to local students as well, as somebody, as Valeria said, it's also important, this English teaching, not only to Erasmus students, but also to local ones. Lessons in my course stretch from general topics such as the history of human rights and the structures of norms on the protection of human rights, the different categories of rights, and universal and regional systems as well, of course, of protection. Along with this traditional teaching, we have prepared a special program by inviting activists from Amnesty International to illustrate some present and hugely debated cases about the international protection of human rights. We encourage in our course a frank and open discussion between the audience and the speakers. To this end, we have also invited some national and foreign scholars who will certainly enrich our debate. I would also like to unveil some of the topics that we are going to deal in our course. They mainly concern rights of groups, personal identity, and gender or ethnic discrimination. They include, for example, gender violence, gender identity, hate speech, apartheid, and racial discrimination. The latter topic will be addressed in the light of the recent Amnesty International report on Israel and apartheid, and the discussion promises to be a very hectic one. Apart from questions of personal identity and discrimination, our lessons will finally deal with 2 more interesting topics. A traditional theme such as the prohibition of torture, alas, and never-ending source of problems and obligation. And also another one, which is very interesting, I think, both for scholars and students, is derogation to human rights, derogation in times of emergency and necessity to human rights, especially, of course, the European Convention on Human Rights. Well, I think welcome to everybody who is interested in my subject, and I will give back the floor to our great Amedeo Arena. Professor Arena, you have the floor.
Thank you very much. Thank you very much, Professor Iovane. I'll now hand over to Massimiliano Delfino, who is going to teach EU labor law.
Okay.
Massimiliano, you have the floor.
Okay, thank you very much for your attention. Thank you to the colleagues. As I said, I'm going to teach European Union labor law, which is a very modern subject matter. I will try to focus on different aspects of these subject matters, starting from an historical perspective, dividing traditional divides the subject matter in three different historical periods: the period of the market, the period of social policies, and the period of the constitutionalization of social rights. I'm going to deal with this subject matter according to the typical partition of domestic labor law, which is the contract of employment on the one hand and the trade union law on the other hand. And so, according to this partition, I will focus on the different topics, such as the directives on atypical work, the instruments of the labor market, the directives concerning crisis and restructuring of undertakings, vocational training. While on the other hand, I will focus on trade union law, as I said, with topics dealing with topics such as the participation, the workers' participation, the European social dialogue. I'm deeply interested in the EU labor laws perspectives, which are very, very important during these times. I would like to make just two examples of the EU labor laws perspectives. The first one is the novelty of a proposal for a directive on adequate minimum wage. And this topic means, first of all, asking the question of whether the European Union has the competence to regulate this matter, the matter of pay. And so during the course, we are going to follow the process of this proposal for a directive, and so it will be very interesting to follow this process. And the other example, the second example, is is linked to two important rulings of the Court of Justice and of the EU Tribunal. And these two judgments deal with one of the key principles of European Union in general, but I think European Union labor law in particular, which is the principle of horizontal or social subsidiarity. And this is a very important topic, and I'm going to deal with this topic thoroughly. Let me conclude my presentation with two items. The first one is the comparison. I'm very interested in comparison, in legal comparison. And so, depending on the country of origins of the students, I'm going to compare the different legal systems, starting from the EU directives, for instance, on atypical work or on transfer undertakings. It could be a good idea to make a comparison between the different legal systems, but it depends on the composition of the class. It depends on how many students there will be in the class, and it depends on the nationalities of those students. And the second item is the items of the interactions with the students. As the students who attended the main course of labor law, of Italian labor law, know, I'm very interested in the interactions between and the students, among the students, and the interactions between the students and myself, since I think that a lecture is interesting when there is an interaction between the teacher and the students, and not the lecture is not a conference. A lecture is not a conference. It's not a presentation, and so the interactions among the students and myself and the teacher is an important component of a lecture, in my opinion. So I think I can finish here, and thank you very much for your attention, and thank you to the colleagues. Thank you, Amedeo.
Thank you very much, Massimiliano. I would now like to introduce Professor Francesca Galgano, who will teach a course called European Legal Science, History and Cases.
European Juridical Science, History, Cases. Let me introduce myself. My name is Francesca Galgano, and I teach European Juridical Science, History and Cases. I'd like to explain a little about this course, which will be taught in English, and it's open to Erasmus students, non-Italian students, and why not also to Italians who wish to broaden their cultural horizons. The level of English will be taught at the European Framework B2. However, it is not necessary to be in possession of a B2 certificate. The course proposes an introduction to the juridical culture of modern Europe, based on ancient legal framework containing foundations for both systems of common and civil law. The course aims to provide an in-depth comprehension of the origin and evolution of legal science through methods and techniques used by past jurists in solving cases, with a focus on some institutions of European law, especially property, family, contract and obligations, to name but a few. The teaching and learning methods will be as follows. The students will be able to identify foundation and evolution of European juridical science through cases. The advantage of such methodology is to install in the students the capacity to analyze text, to identify legal rules and principles applicable to specific cases, to argue logically, and, when possible, to give examples and solutions. The course is based on primary materials, which are absolutely necessary to shape one's own assessment on single cases. Through lessons and teamwork held during the course, the students will be able to apply the technical language and know-how. Oral assessment, 30%, will be conducted during the course and will be finalized through an oral exam, 70%, at the termination. And now the crucial question, why follow this course? The first approach to European juridical culture will be focused on its history, but the perspective is launched towards today's Europe, though we can't ignore the influence that a common intellectual tradition has given us, that was consulted and used in medieval Europe, from where it was exported around the globe. It is the base of many modern legal systems today. The quality of this intellectual and juridical culture was extremely high, especially as far as concerning a way of reasoning, of constructing patterns using logic, which has survived throughout the centuries. And finally, another important aspect to be underlined regards European identity, which could be regarded and enforced by the understanding of a common legal culture still present in court decisions, and even outside Europe, providing inspiration. Thank you very much.
And it's now time to hand over to Luigi Ferrara, who is going to teach EU and comparative administrative law this year. Luigi, the floor is yours.
Thank you, Amedeo. Dear student, good afternoon. First of all, I would like to warmly thank you, Professor Arena, for this webinar and all colleagues introducing us. My name is Luigi Ferrara. I am Associate Professor of Administrative Law. You may find all information about my academic activities on my university personal webpage. I am very glad to introduce you the course of Comparative and European Administrative Law. The course provides a comparative introduction into administrative law models in civil law and common law countries. We will analyze administrative system in France, in Germany, in United Kingdom, and in USA. Administrative law was built around the key concept of governmental power, linked as a typical national product, closely linked to local tradition. However, from 19th century to date, the comparative analysis was frequently the rationale for relevant statutory reforms of public administration in several countries. You may consider, for example, the recent Italian reform of administrative transparency, starting from the USA model of freedom of information. Administrative courts, similar to the French Council of State, flourish in several European countries, such as in Italy. Scholars and intellectuals were constantly involved in comparative analysis of public discussion about the common trends in different countries. In civil law countries, the foundation of national legal sciences involved a process of circulation of principles and tools of administrative law, like the judicial review of discretionary power, the status of administrative procedure, the shape of local government. In UK, Dicey and English legal scholarship represented the United Kingdom as an exception to diffusion of administrative law in the name of the primacy of both rule of law and common law system. Today, with the creation of a specific judicial review of administrative activity and a special section of the ordinary courts, UK scholars underline that even in England, administrative law is a field apart from private law, influenced from influencing foreign administrative law models. In USA, starting from New Deal reforms in 20th century, scholars told about the rise of the administrative state in America. The American system of administrative law moves away from common law tradition and suggests trend and issue very interesting in comparative perspective with civil law countries. The Constitution and administrative law interact to shape the rights and duty of citizens due to activism of courts. In this course, I will show you the leading cases which in each country shaped the physiognomy of national system. The course focuses on the following topics. We will start from technical methodological choices which comparatives had at disposal: functional comparison, structural comparison, systemic comparison, and critical comparison. We will analyze in selected each country the administrative organization and the general principle, the shapes of public administration, activity and right of citizen, general law regulating the administrative procedure, the judicial review of discretionary power, and administrative courts and tribunal, the local government. We will analyze the convergence and integration among national models today. In particular, we will analyze the so-called European administrative law and so-called global administrative law. Over the last decades, the European Union has developed a series of ad hoc administrative procedures for a direct implementation of its rules. The German scholar Schwarze proposed that the European integration process had been built around a community of administrative law, and that the new EU administrative law influences national administrative law. Over the past 30 years, the process of globalization impacted upon a legal institution as much as the economy. Global regulatory regimes, intergovernmental organizations, global standards, and so on, developed principles and rules that are mainly administrative in nature, relating to the process of law, procedural fairness, transparency, participation, duty to give reason, and judicial review. With Kingsbury, we could define global administrative law, the legal framework of this mechanism, principle, and practice. The course addresses both Italian and Erasmus students and will be carried out in Italian and in English. The course consists of lectures and seminars using slides in English. Registration and regular attendance in lecture are recommended. The lecture timetable might be changed and agreed with attending students. The final exam will be a comprehensive oral discussion. Attending student may agree an intermediate exam with lecturer. The text for final examination are one handbook and one paper, both at choice. Student can choose one book between two suggested handbooks in Italian and English, and one paper among several suggested papers. Suggested paper and course slides will be given to the attending students. All news and information will be published on my personal university website. The skills that attending students may get are the knowledge of administrative law in some foreign countries and EU and global administrative law, the understanding of the trends of future reforms in administrative matters, and the capability to promote themselves as experts for careers abroad. Attending students are welcome in preparing their final examination thesis. I will help them to study in foreign universities. Thank you for your attention and enjoy my course.
Thank you very much, Luigi. And I will now hand over to Marcello Stella, who is going to teach international and comparative procedural law this year. The floor.
Thank you very much, Amedeo, and welcome to everybody. So my course is about civil justice in a comparative and transnational perspective. So it is sort of a blended course. I try to, in the first part, give a little brief bit of a history of the main procedural law families in the European landscape. That would be Germany, France, the UK, and Italy, of course. And we try to grasp what the main values underlying the civil justice systems are. And we do that by having a look at the main phases of civil trial. So the introductory phase, the taking of evidence, the appeals available against decisions, and finally the res judicata effects. And also a brief look at summary procedures, summary judgments. It is really a great, fascinating time to take, this is the second year I'm taking this course at the Naples University. Really fascinating time, as in all member states right now, or in the last 2 or 3 years, there has been a great amount of reforms of the procedural law systems. And all those reforms and main remarks, values, have an impact, a tangible impact, when we shift to the transnational perspective. So when we deal with transnational litigation and issues of jurisdiction, taking of evidence, recognition and enforcement of judgments, all those peculiar features of each civil justice system, they really become evident. And so in the second part of the course, I focus on especially the civil commercial litigation, and in particular, we deal with Regulation 1215 of 2012, the Brussels one-piece regulation. So we have a look at issues about international jurisdiction and recognition of judgments. In the course, I will show students different judgments by different courts of the member states. The style of reasoning of judgment tells a lot about the procedural systems. We will have a look at the main case law by the European Court of Justice in Luxembourg, of course. I will assign short English language readings, brief readings by comparative procedural lawyers, and of course, attendance and participation in classes will be also evaluated in the overall final oral exam. There will be an oral exam at the end of the course. And that will be it for my course. Yes, thank you.
And thank you very much, Marcello. So I'll now hand over to the presentation of the course of History, Modern and Contemporary Codification. So we have Professor Dolores Freda, connecting from our Faculty of Law. Dolores, you have the floor.
Thank you, Amedeo. Thank you to everybody. History of modern and contemporary codification focuses on the idea and process of codification in Europe, and starting from the affirmation of the modern state in the 16th century and enhanced first by the natural law theories, then by the Enlightenment, concentrates on the enactment since the end of the 18th century, more or less, of the main modern and then contemporary codes of law. And it should be noted that if it's true that such a process, such a history concerns especially continental Europe, at the same time the debate on codification developed widely in the common law world, enhancing the codification process itself all over Europe and all over the world. Furthermore, particular attention is given in the course to the debates, to the theories, of course, with an eye to the most recent historiography, or historiographical and doctrinal scholarship, which contributed to the evolution of codified law in the 20th century, with particular reference to the historical experience on one hand, but also on future perspectives on the other of the form code itself, especially in present debate on the European law. And if possible, I will just add I would like to add that the educational offer available in the legal historical field is not limited for this year, but especially for the next year, to history of modern and contemporary constitutional law, but includes also some other subjects, as for example, history of criminal law, which focuses on the development for the centuries of criminal legal thought, criminal process, criminal systems in an historical comparative perspective, history of the legal professions, on the origins and development of the legal professions, so advocacy, judges, notaries, with particular reference to Italian legal culture, but also in a comparative European perspective. And last but not least, history of labor law, on labor legal history, always in an international framework or perspective, which crosses, in this case, women labor issues and migration-related issues. So that's all for the historical subjects, and I thank you very much.
Let me thank you, Dolores. That was absolutely fascinating. So let me now hand over to Loredana Strianese, who will teach a course called Decentralized Finance, Policies and Laws.
Hello everyone, I would like to thank Professor Arena for this user-fine initiative which gives us the opportunity away in a few minutes to present our course. Well, I introduce it now. I'm Loredana Strianese, and my course is called Decentralized Finance Law. It is a course of choice in the 50 years, and it deals with the financial autonomy of regions and other territorial entities. The subject of the study is a history of fiscal federalism in Italy and the constitutional reforms that have characterized it. In particular, it focuses on the study of local taxes and their wide development and the different territories, especially because many of them have an extra-fiscal connotation because, being special purpose taxes, the revenue obtained from their collection is used for the preservation of cultural and artistic heritage and also for environmental protection. The tourist tax or the landing tax, for example, are very effective taxes and are also applied in other tourism-oriented countries around the world, not just in Italy. They help to finance local budgets by encouraging and supporting the implementation of public works on the territory in favor of the environment and landscape protection. These are very innovative topics because they are currently the subject of many legislative reforms aimed at developing the competencies and these bodies, especially with regard to the management of the new PNRR, and therefore to the realization of works on territory that are useful to the citizens living in the individual territories. Foreign status will be granted a simplified examination program. I will stop here and thank you for your kind attention. Bye.
It is now time to hand over to Francesco De Santis, who is going to teach procedural aspects of human rights protection. Francesco, the floor is yours.
Thank you very much, Amedeo. Good afternoon, dear colleagues. Good afternoon, dear students. It is a real pleasure to me to have the opportunity to present my course. This course is the procedural aspects of international protection of human rights. I held it in Napoli University, in Federico II University, right since I got back from my working experience at the Registry of the European Court of Human Rights. So just to, as a teaser of, let's say, of my course, I would like just to remind that today, the European Court of Human Rights has granted urgent interim measures in application concerning military operations on Ukrainian territory. Those interim measures had been granted ruling on a request brought by Ukrainian government pursuant to Rule 39 of the Court Rules of Procedure. Maybe for let's say the majority of the students who will look at this video, what I said so far is totally meaningless. And you will discover what I was talking about during my course. This subject is focused on the mechanisms for the international protection of human rights, international mechanisms, and a special focus is made on the European Court of Human Rights, which is the, let's say, accordingly known as the most important international court for the protection of human rights in the entire world. My perspective is not only that of an international lawyer, but also the one of an associate professor of civil procedure. So we will study it starting from a technical perspective, thinking of the Strasbourg Court as a Supreme Court of Europe in a way. What can I say? Let just me add that you will find all the information on my course on my teacher webpage. Actually, I'm glad to repeat what my colleagues said today. This is during the years, this course has been attractive not only for Erasmus students, and I'm glad to have Erasmus students because I like to to continue this idea of building an international environment in our university, but a real one with human exchange among people. But this course has been very catchy also for, and mainly I would say for Italian students, or students who wanted to continue an international career after their graduation. And apparently it has been of some help. So you are the most welcome every Thursday and Friday morning in room 32, starting from 9 o'clock. And I can assure you it will be interesting. Thank you, my dear.
Thank you very much, Francesco. And I think I hand over to Professor Giovanni Zarra, who is going to teach EU private international law. Giovanni, you have the floor.
Thanks a lot, Amedeo. I'm very happy to introduce my topic in this seminar. Actually, private international law is today crucial in EU private relationship because, as you know, free movement of people is going to increase the number of relationship between people coming from different countries, as well as increasing the number of legal relationship involving an element of a foreign element with regard, for example, to the delivery of goods or something similar. Let's think even about a journey of somebody from Italy to France or Portugal or Spain or whatever. I will teach this topic as I actually learned it in the UK when I was a student, an LLM student at Queen Mary University of London. And I will provide students with slides concerning the topic in advance. The lectures will be oriented by the EU regulations on private international law. So very few space will be given to the Italian law on private international law, which is more or less completely disapplied today. And obviously, the explanation of the topics will be driven by case law. So mainly we will analyze decisions from the Court of Justice of the European Union and discusses the various topics on the basis of the practical approaches related to the various issues that will be analyzed in the during the course. I think it's enough. I very welcome people interested in the topic, and I'm available to answer to any question in this regard.
Thank you very much, Giovanni. I'll now hand over to Professor Loris Marotti, who is going to teach international investment law and arbitration this year. Loris, you have the floor.
Thank you very much, Amedeo, and good afternoon, everyone. So the module will be on international investment law and arbitration, which is, I would say, a very fascinating and modern topic and a very intriguing branch of modern public international law. It deals with the protection of foreign investments, and it is based on a tension between this need of protection of investors and the need to protect and safeguard states' regulatory autonomy. So it's a very pressing topic, and it has a long history, and now there has been a very long and very important evolution in this topic since the 60s. So we had a proliferation of investment treaties and a proliferation of investment arbitration, so-called ISDS. So the case where an investor can sue a state before an investment tribunal. So in the module during classes, we will discuss and we'll examine all these issues and all issues related to the public international law issues stemming from this very particular branch of international law. The course will be divided into 6 parts. So we will have a first part based on the history of international investment law. Then we will move to definition of investment, of investors, and then we will move to the analysis of the standards of protection of investors and investment. And then we will move to ISDS, so the arbitration between states and individuals and investors. And finally, we will address a very pressing an important topic, which is the new approaches taken by states and international organizations such as the European Union towards the investment system. So classes will be based on an approach which would be based on the dialogue between me and you, students. So I will try to promote interaction and discussion with students. And let me also say that if you get bored of my voice, I will also invite guest speakers, external speakers, who will discuss with us more specific topics. So we will have seminars on other and more specific topics on international investment law. Thank you very much for your attention.
Thank you very much, Loris. It's now time to say a few words about the course I will be teaching this semester, which is called European Union Law in Action. So what is that about? Essentially, this course will focus on fundamental freedoms of the EU internal market on the one hand, and on EU competition law on the other hand. So did you know that you can freely travel, work, study, set up a company, invest in money in 26 other member states, different from Italy? Well, this is thanks to the fundamental freedoms of the internal market. Instead, the goal of competition law provisions is to ensure low prices for consumers, product variety, service variety, as well as continuous investment in innovation by private companies. The Treaty of Rome in 1957 introduced these two sets of provision on internal market and on competition law to pursue these goals, which of course are conducive to the overall goal of the European Union, which is integration and peace in Europe through economic integration. So this course will adopt a flipped classroom methodology. So that means that the student will be in the driver's seat. The student will be assigned one case to report on, and he or she will report on this case and discuss this with other students in interactive fashion. And also, part of this course will be made of guest lectures. We have already 5 confirmed guest lecturers from other member states, and some of them in particular are practitioners, which enables me to point out the title of this course. It's called EU Law in Action, because it's not only what you can read in the books, but it's also what happens in practice. And so to get a better idea of how EU law actually affects the life of people, the bottom line of companies, we will have the opportunity to discuss the application, especially of competition laws, with lawyers, so people that apply these provisions on a daily basis. Finally, why should you pick this course? Well, first and foremost, to get a practical insight of your rights as a European citizen, and that is also part of an empowerment process. Second, to experiment with a new interactive methodology that might be different from the one you are used to. And finally, to interact in a multicultural environment that will provide some valuable experience should you wish to pursue part of your legal education or your career, your future career in the whole EU, in the whole European Union. So, and with this, I think I can thank all the colleagues who were so kind to take part in this webinar today. Thank you very much, everyone. And I guess we'll meet all the students in the classroom.